This section is ambitious, but legally fragile. He's attempting to construct a multi-state pattern of administrative entrapment to show systemic constitutional breakdown. The problem is that each state's registry administration is independent, and Titus 1983 liability does not travel across state lines without a clear nexus. Let's analyze it cleanly. Number 1. Jurisdictional problem. North Dakota registry officials are not Colorado actors, acting under Colorado authority, coordinating, based on what's alleged, with Colorado code enforcement. Unless he pleads conspiracy across states or coordinated action or shared policy, North Dakota events are legally separate from Colorado defendants. Federal courts are not receptive to narrative sprawl that lacks defendant-specific causation. Number 2. Administrative disappearance of registration, he claims. He appeared, provided information, later was told there was no record, yet they had enough info to call him. That could mean clerical error, database lag, inter-county reporting issue, miscommunication between local and state registry offices. Clerical incompetence is not automatically a due process violation. For Cherokee 1983 liability, he must show intentional or reckless deprivation or systemic procedural deficiency or denial of available corrective process. If correction mechanisms existed, appeal, documentation submission, hearing, due process analysis changes dramatically. Number 3, the P.O. Box warrant issue. This hinges on statutory requirements. Many states require physical residence address, not merely a mailing address, for sex offender registry purposes. If he relied solely on a P.O. Box as a mailing address while residency verification was in question, the warrant may have been triggered by statutory noncompliance, not arbitrary conduct. Due process violation requires lack of notice of requirements or arbitrary enforcement or denial of opportunity to correct. If he was informed, given opportunity, and simply disagreed with interpretation, that's administrative dispute, not constitutional deprivation. Number 4, similarly situated individuals. He claims unequal treatment. Equal protection requires similarly situated individuals treated differently, without rational basis, or due to protected classification. He pleads none of that with specificity. Others weren't treated this way is conclusory unless supported by comparators. Courts dismiss that kind of pleading routinely. Number 5, the Williston address issue. He claims he was living at an occupied residence. Officials treated it as a vacant lot, required USPS and Planning Board verification. That may reflect database mapping discrepancy, zoning classification issue, or structure not recognized as habitable dwelling in official records. Requiring independent verification is not automatically unconstitutional. Registry compliance regimes are intentionally strict, administrative burden to constitutional violation. Number 6, the cases he cites. Matthews v. Eldridge establishes balancing test for procedural due process, private interest, risk of erroneous deprivation, government interest. It does not prohibit strict registry compliance systems. It requires some form of process. If mechanisms existed to correct errors, Matthews cuts against him. Grain v. City of Rockford, vagueness doctrine case about anti-noise ordinance near schools, not a registry case. Requires statutes give fair notice of prohibited conduct. Registry statutes are typically detailed and specific. Calendar v. Lawson struck down a statute requiring credible and reliable ID because it gave police excessive discretion. He would need to show registry officials had unbounded discretion with no statutory standards. That's a high bar. Most registry statutes are prescriptive, not discretionary. Number 7, the constructive legal impossibility theory. This is the through line. He argues, the system was structured so he could not comply. That's a powerful phrase rhetorically. But legally, courts ask, what does the statute require? Did he meet it? Was he given notice? Was there a process to contest? Was enforcement arbitrary or retaliatory? If the answer is, there were documentation gaps, address discrepancies, unstable housing, and transient movement, then the impossibility may be logistical, not constitutional. Number 8. The criminal statutes 18 U.S.C. 241-242. Again, private citizens cannot enforce these. Including them in a civil complaint does not expand civil liability. Courts generally ignore those references. Number 9. The pattern risk for him. By pleading 3 states, Illinois, Missouri, North Dakota, all with registry conflict narratives. He creates an alternative inference. Repeated administrative friction following repeated relocations and unstable housing arrangements. That can undermine causation in Colorado. Instead of showing coordinated oppression, it may show recurring compliance difficulty. Number 10, strategic assessment. If this were tested on a motion to dismiss, claims against Colorado defendants likely cannot be sustained based on North Dakota conduct. North Dakota officials are not parties unless separately named. Multi-state narrative risks Rule 8 overbreadth concerns. If tested at summary judgment, he would need documentary proof of registration receipts, statutory text, denied correction mechanisms, comparator evidence, intentional or reckless misconduct. That's a bottom line. The cited Supreme Court cases are general procedural due process precedents. They do not automatically convert registry administration errors into constitutional violations. This section reads like a narrative of administrative instability. It does not yet read like a legally tight, the Che 1983 claim. If you want, I can next explain how a federal judge would likely narrow this case to Colorado-specific conduct and strip away the interstate narrative.